Back on the record in the matter of the people or the matters of the people of the state of Michigan versus Maddox, Burden, Fascinello, Haggard, Henry, Lundgren, and we are going to reset Thompson. Council appearances, please.
Good afternoon, LaDonna Logan on behalf of the people.
Good afternoon, Nicholas Sandberg on behalf of Michelle Maddock.
Good afternoon, George Danini on behalf of Kathleen Burden and also Garrett Koger on behalf of Kathleen Burden.
Good afternoon.
Good afternoon, Your Honor. Paul Stavlin appearing on behalf and with Ms. Fascinello.
Good afternoon, Your Honor. Mary Chartier on behalf of John Haggard, who is seated to my right.
Good afternoon, Your Honor. Kurt E. Kraus on behalf of Mr. Haggard, who's also seated to my right.
Good afternoon, Your Honor. George Brown on behalf of Mary Ann Henry, who sits to my left.
Good afternoon, Your Honor. Dwayne Silverthorne on behalf of Michelle Lundgren, and I'm awaiting her. She has some ambulatory problems. I don't know. I haven't been notified. I asked downstairs. I went downstairs, and the guards were familiar with her and indicated that she had not passed by yet.
Okay, I will give you an opportunity to go see if maybe she's sitting down where those chairs are, or someone could probably check the women's restroom if that's not her.
Not yet. I just discovered a few minutes ago. I will check.
Okay.
Right back here.
Your Honor, assembling. We have a question just regarding timing. When is the court going to conclude today?
Well, we're just doing a redirect and then we're concluding for today.
There's one witness who would be very brief. Can we call that one witness and then conclude?
Depends on how long your redirect takes.
It will be brief-ish,
Okay.
but the one witness, I'm just thinking because he drove up from Detroit and
Okay.
I think he'd be very quick.
They have the right to make their objections, and then it could be 6 different objections.
I'm gonna try and streamline this. Some of the shows and maybe leave it now.
Okay, now we're back on the record, and Mr. Silverthorne has relocated his client.
Yes, for the record, she is now standing to my left.
I apologize. Thank you. And the prosecutor was, I think, getting something clarified with an exhibit. Is that what was going on? I don't know if you got a chance to talk to Mr. Silverthorne.
I did not.
So they put a copy in the file for him.
I'm ready to do my redirect, and we may be able to squeeze in that one short with me.
Okay, we'll see. It's up to you all, not me. You can proceed.
Thank you. Mr. Brader, during your cross-examinations, you were asked by a couple of attorneys regarding the Senate taking testimony regarding fraud in elections. Do you remember that question?
State legislature?
Yes, the state
Uh,
Senate.
state
Excuse
Senate?
me.
Oh, yes.
And do you remember also being asked on cross about prominent members of the Republican Party also making numerous statements about the possibility of fraud in the state election for president?
Yes.
Now, at the time of the 2020 presidential election, do you recall who was the Speaker of the House?
State House, that would have been Lee Chatfield.
And who was the Senate Majority Leader?
Mike Shirkey.
Do you recall if either any of the statements that you heard from the Republican Party came from Senator Shirkey or Rep. Chatfield?
I remember them making statements.
Do you remember when the statement was made?
Not specifically, no.
Now, was the statement in reference to any actions that the state Senate or House would take as far as the Michigan results, election results?
Yes.
And do you remember what action either Senator Shirkey or Rep. Chatfield, well, both of them said the state government would take?
Generally, I remember them saying that the state legislature is not going to seek to change or.
Excuse me, objection as to hearsay. I think if the question is what was done, that of course wouldn't be hearsay, but the statements themselves are.
Well, one, it's a statement of intent, which has been removed from hearsay, and two, the door was open on cross when they were asking about what Republican members of the Senate and the House were stating about election fraud. And these are a statement of intent from both the leaders of the House and the Senate about what, if anything, the government was going to do about that election fraud or perceived election fraud.
I don't believe I asked what senators or representatives were saying. I asked if Mr. Brader knew if testimony was taken regarding allegations of fraud.
Your Honor, just so the record's clear, Kathy Burton joins in the objection, and I would note that neither on direct nor cross-exam nor specific senators or state representatives named. So it's beyond the scope.
It's,
In addition to Ms. Chartier's objections.
Anybody else?
Maddox would adopt the objection.
Paul Stabler, joining the objections.
Marion Henry joins the objection.
Michelle Lundgren joins in the objection.
Okay, you can respond.
My response is, Your Honor, the door was clearly opened on cross. It was not opened on direct, but it was opened on cross when Mr. Rader was asked several times about statements. They were asked in general, he was asked in general about statements made by several members of the Republican Party. And these are specific statements of intent about what the Republican Party either would or would not do about election fraud or election.
Remind me of your question posed to this witness again,
I don't remember anymore.
counsel.
I don't remember that either.
I
I,
think
I, I,
Oh, boy.
I believe what I asked is if the witness recalled whether or not both Senator Shirkey and Rep. Chatfield made a statement of intent regarding what the government would or would not do regarding the state election result. I think it was better worded, but
Okay.
And
Counsel,
just add, as it relates to.
the questions I was asked.
Yeah.
I think it was your questions that she's referencing.
No, I never went into statements that they made, but we could, I'd be happy to wait for the transcript to be read. With respect to what the Republican Party was going to do as it relates to Senator Shirkey and Representative Speaker of the House Chatfield, that would have been done in their official capacity, not on behalf of the Republican Party. So just so the record's clear, we're talking about two different capacities, and I would wait for the court's ruling on the objection, Your Honor. Thank you.
we also.
Counsel is standing. Do you have another
Yes, Your
objection?
Honor. So George Brown from Marion Henry, just even if a question was asked, if a statement of intent had been made, it doesn't open the door for hearsay about any content, any statement.
It's a statement of intent, so it's not hearsay.
Okay. As to whether or not. Sorry, let's turn their Polycom down. As to whether or not the door was open during cross-examination, my recollection is that the door was open as to this line of questioning. And my recollection is that it was open during Mr. Kroger, Counsel Kroger's line of questioning. As to whether or not this is a statement of intent, your question is to whether it was whether or not these leaders indicated to this witness what they intend to do.
Well, they made a public statement as what the House or the Senate would or would not do as it related to the election results.
You're asking, was he aware of any public statement? Is that what your question is? Or
Yes,
did they
he
make?
heard.
He can answer if he was aware of any public statements, so that objection is overruled as it relates to hearsay. I'll allow you to renew your objection if the question continues.
I was aware of public statements.
So did Senator Shirkey and Rep. Chatfield issue a statement regarding what they would do as it related to the Michigan presidential election results?
Yes.
And what was that statement?
Objection.
Hearsay, I'm sure. Is it the objection?
Yes, same
Okay.
objection.
Okay, and your response was a statement. It's a
It's
statement of intent.
intent.
Mr. Kroger, I saw you peek up.
Just join in the objection, Your Honor.
Okay, is anybody else joining? Or I think you all joined previously. I just said I'd continue the objection if the line of questioning proceeded. As to it being a statement of intent, the objections are overruled. You can continue, you can answer the question.
Thank you. What was that statement?
What I recall is they said they were not going to attempt to change or overturn the results of the presidential election in Michigan.
And to your knowledge, that statement was publicized, correct?
Yes.
Now, on December 14th, 2020, was the Capitol building flooded?
No.
So it was available for the duly elected electors to go and perform their civic duty.
Yes.
Was there a recount request after the State Board of Canvassers certified the vote?
No.
Was there ever a recount?
No.
Did any court, state, local, or federal, ever move to issue a temporary restraining order, or stop the electors from entering their votes.
No,
The lawsuits as they pertain to alleged fraud in the presidential election, to your knowledge, were those all dismissed before December 14th, 2020?
I don't remember.
Were they dismissed?
Yes, I believe so.
And you just don't recall the date?
Yes,
And it was still the Democratic electors that were chosen and selected and certified to vote the 16 electoral votes for the state of Michigan. Is that correct?
yeah,
Permission to approach, Your Honor?
Yes.
So I'm gonna hand you Exhibit 7 again. And I'm gonna ask you to look at the second page of that document. I believe the title page is memorandum.
yeah.
Okay. Now, on that page, there are listed several people that this is addressed to. Who are those people?
The President of the Senate, United States Senate, the Archivist of the United States, the Secretary of State, State of Michigan, and the Chief Judge of U.S. District Court for the Western District of Michigan.
Now, other than you receiving this in your email, are you aware of the Secretary of State receiving this document?
No,
And it's fair to say that you would not be in a position to say whether or not the President of the Senate or the Chief Judge of the Western District of Michigan received a copy. Is that correct?
correct.
Now, can you turn to what is the third page of that document, titled Certificate of Votes of the 2020 electors from Michigan?
Yeah.
Now, there are 3 certifications that, well, there are 3, I guess, I don't know if I want to call it certifications, please check that. There are 3 statements that are made on that document before the votes are designated to President Trump and Vice President Pence. Is that correct?
Yes,
And what is the first certification?
it says that we convened and organized in the state capitol in the city of Lansing, Michigan, and at 2 p.m. Eastern Standard Time on the 14th day of December 2020, perform the duties enjoined upon us.
And what was B?
At being so assembled and duly organized, we proceeded to vote by ballot and balloted first for president and then for vice president by distinct ballots, and
C?
that the following are 2 distinct lists, one of all the votes for president and the other for all the votes for vice president, so cast as aforesaid.
And at the top, the "we" is identified as the duly elected and qualified electors for president and vice president of the United States. Is that correct?
Correct.
And looking at the following page, page 4, is that the page that contains 16 signatures?
Yes,
Now, you were asked on cross, if you received that page alone, would you think that it belonged with other documents? Or at least another page? Do you remember that question?
yes,
And the fact is, you did not receive just that signature page, is that correct?
that's correct.
The pages that are connected with Exhibit 7, those all came to you together, is that correct?
Yes,
Now, I'm gonna ask you about the signatures on there, and I'm not gonna ask you to verify the signatures, but I'm gonna ask you about the names under the signatures and if these names are present. Is Kathy Burden on them?
yes,
Michonne Maddox,
yes,
John Haggard,
yes,
Amy Facinello,
yes,
Mary Ann Henry,
yes,
Michelle Lundgren,
yes,
Ken Thompson.
yes.
Nothing further, Your Honor.
I mean, this would just be excused.
Yes, please.
Thank you. You may be excused. I am going to advise you that there is a sequestration order, so you're not to discuss any portion of your testimony with any other witnesses. Okay, sir?
Yes, Your Honor.
Thank you. You may be excused.
Thank you.
Call your next witness.
Johnson.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can have a seat. Okay, I need you to state your first and last name and then spell both.
My first name is James. My last name is Vandeputty, V like Victor, A-N, space, lowercase d-e, space, capital P-U-T-T-E.
You can proceed, counsel.
Good afternoon, sir.
Hello,
Where do you work?
I work for the United States Postal Inspection Service.
And how long have you been so employed?
I've been there around 9.5 years.
Now, on January 11th, 2023, were you contacted by a special agent of the Attorney General's
I
office?
was.
And do you recall the nature of that contact?
He requested information related to a parcel that was sent via the United States Postal Service.
And were you provided any information to be able to look into that parcel?
I was provided a picture of the parcel, which also contained the tracking number.
Okay. And if you have a tracking number, are you able to find any information or some information about a parcel?
Generally, if the tracking number is legitimate, it will show up in tracking systems, correct?
Permission to approach, Your Honor?
Yes.
And this document has been previously shown to all parties. I'm going to show you what has been marked as People's Proposed Exhibit 11. Do you recognize that copy?
I do.
And what is that?
That is a copy of the parcel that was, the information that's being requested.
And does it have a registration number? Is that the appropriate term?
Yeah, the tracking number is right on the front of the parcel. And as you can see, it says registered mail, and then it gives a registered mail tracking number starting in RE at the bottom, beneath the barcode.
Okay. And were you able to determine if that was a valid number?
It was a valid number.
What, if any, information were you able to ascertain for that tracking number?
We were able to determine that particular tracking number.
Objection. There's multiple people jumping up. So he said we, and I don't think that he should be testifying as to what a team did. So I would just ask that he clarify as to what he did.
Okay.
Wait 1 second.
This might be a technicality, but I don't think it was moved to be admitted yet.
I have not moved for execution.
Okay. Should that happen? I would say that should happen before he starts testifying about what it is, as far as what he did with the information, what he gleaned from the information, so on and so forth.
Counsel, you sat down, but what was your objection?
That he wasn't testifying from his personal.
Okay, sounds good. The we. Okay, as to, let's first address as to the objection to we. We would mean that, or could mean that there's some hearsay involved there. You can only testify as to your own personal knowledge, okay, sir?
Yes,
So
ma'am.
I'll sustain that objection, and then you want to address the exhibit.
I will move for the admission of People Proposed 11. I believe it was provided to councils as 2 documents. It is currently only 1 document, and it's just what has been authenticated as the witness had received to investigate.
Any objections to People 11? Okay, People 11 is admitted.
Could you just read into the record the tracking number?
Sure, the tracking number is RE 041 878 637 US.
And were you able to determine if there was any information that had not expired as it related to that tracking number?
Yes, I'd like to clarify. When I say we, I work with analysts, and I submitted this tracking number to an analyst who was able to provide me that information.
Is this information that's kept in the ordinary course of business?
Yes,
And so the information as related to that tracking label, were you able to, what were you asked to look for as far as information?
Payment method, I believe was the main determination, and then whether or not it was delivered. I believe.
And were you able to determine a payment method?
Yes.
Okay, and what was that?
I'm gonna
Cash.
object, so it sounds like an analyst did this work and then told the information to the witness. I don't, this is, I heard the Attorney General say something about this is kept in the ordinary course of business. That's a business records exception, but if we want to have a business record, we're talking about apparently some data or something that was not discovered by this witness, but by somebody else.
I agree with counsel, and with an investigation, the result of that investigation would not be something that's kept in the ordinary course of business. That a business record is something like a timesheet or some other sort of record. It's not investigating a case. I think what this witness is testifying to is actually hearsay of what he's being told by another analyst.
Kathy Burden joins in the objection.
Sean Maddock joins in the objection,
Michelle, have you joined the objection?
as does Mary Ann Henry.
And did you want to address that objection? Because I don't know what he's testified. I don't know if analysts provided him that information. He's just talking about the information he got from them, or if they provided him the documents that he used to discover this information. I don't know.
I think I can ask some clarifying questions.
Okay, I'll make a ruling after we get some clarifying questions.
Thank you. Now, the information that is tied to that tracking number,
Yes.
is that information that is retained by the United States Postal Service, United States Postal Inspection Service?
Yes.
Now, if someone requests information from you, is there a procedure that is in place for how you would get that information?
It depends on the nature of the request.
Let's just say the nature of the request is just like in this case where they're asking if you can determine method of payment and date of delivery. How would you get that information?
I would ask my general analyst to run the tracking number and make those determinations.
Okay, and then how would you get that information?
He would then email me or discuss it. He works right down the hallway with me to let me know what information he was able to find.
And do you do anything to determine, to check that information, make sure that is accurate?
I can run the tracking number and make sure some of it is accurate.
Mhm.
And if he provided me with the report that he ran, I can verify it.
Mhm.
I do not remember if he provided me with that report, but in the general course he would.
In the general course, he would provide you with the report, and would you also follow up with that report just to make sure it's accurate before you disseminate that information?
At that point, I would just let the person who requested the information know this is what
You're gonna,
I
I'm
was
just,
able to find.
excuse me, I'm going to object because what's being discussed here is what he may or may not do in another case. What's relevant is what he did in this case. And this gentleman admitted he doesn't remember if he checked or verified anything. What he's coming in to talk about is what someone else did. He's got no personal knowledge of that. It's being based on hearsay, and that other individual made a determination. That's what he said. So that's not something that's a record that's kept in the ordinary course of business.
So, Your Honor, the fact of the matter is this information is kept in the ordinary course of business. And so it is readily available to this witness, to his analyst. And even if there's an objection to the form, that doesn't make it any less a business record, the information that we're discussing here.
He doesn't know that he doesn't know or remember in this particular case how he got the information though.
No, he says he originally got it from his analyst, and the analyst would usually provide him with a report based on his request to say, can you look into this tracking number?
Or could have called him, he said. Usually, or could have called and he can't recall what happened in this case.
Mhm.
I agree with the court's analysis. He's really saying that he might have got it one way, he might have got it another. He could have gotten it from a phone call, which is a fancy way of saying, I don't know how I got it, but there's various ways. You typically will get information like this, which doesn't cut it here.
Well, Your Honor, I think what we're talking about is the medium in which the information was relayed, but the answer has always been that the information was provided by the analyst. The question is, was it in written form or oral form? And either way, it's still information that would have been kept in the ordinary course of business.
Yeah, but there's a huge difference between the analyst providing him a report, an email that he's reviewing versus an analyst calling and said, yeah, I ran a report and this is what it said. Huge difference.
There is. You don't recall which one?
I believe he sent an email with a report containing a spreadsheet with the tracking number information.
That's different from his previous testimony.
It is different from his previous testimony, and I'm very curious if that email has been provided to the
My
Attorney General's
apologies.
office.
Might I-
Well, we'll allow you to ask him that on your cross-examination because he has changed it. It does change the nature of this information. I'll overrule the objection, and then you all can flesh that out on your cross.
Now, as it related to payment method, were you able to determine a payment method?
Yes,
Okay, and what was that?
cash.
And when someone pays for a registered mail by cash, do you keep any information about the identity of that person?
No,
And the second question you said you were asked was date of delivery. Was that information still available?
yes,
And what date was that?
January 5th of, I don't remember the year, but it was in the report.
What, do you recall what date the package was sent?
It was sent December 15th of 2020.
For the record, you're refreshing your recollection using the exhibit, correct?
Correct.
And does that refresh your memory as to the delivery date?
That would have been January 5th of 2021.
Nothing further this witness, Your Honor.
Thank you, Your Honor. Did you say it was Vandeputty?
Yes.
Okay, great. I just wanted to make sure I
It's
pronounced.
terrible.
No,
Yeah.
well, wait till you hear mine. It's Chartier, so it's also a tough last name. I have some questions for you. I want to talk about the email that you just mentioned that you believe you got from the analyst.
Sure.
Are you certain you got an email or you're not sure? Where are we with
I
that?
would have to double check.
Okay,
Yep,
so as you testify here today, you don't know if you got an email from the analyst.
not with 100% certain.
And what was the analyst's name?
His name is Richard Strickland.
Richard Strickland? Was he the only analyst who was working on this?
He was the one I requested it from, so I believe so, yes.
And if you had gotten an email from him, would you have forwarded that to the Attorney General's office?
I did not.
You did not, okay. So when you may or may not have gotten an email from Mr. Strickland, then do you remember if you spoke to him on the telephone at all?
No.
Or did you said his office was right down the hall from yours?
Correct.
Okay, so if you did want to talk to him about this, is it accurate you would have gone and spoken to him face to face?
I could have, yes.
Okay, but you don't remember doing that? Okay, so just to be clear, you don't remember if you got an email, right?
Not with 100% certain.
Not with 100% certainty. You don't remember if you spoke to him on the phone,
Correct.
and you don't remember if you went to go talk to him.
Correct.
Other than speaking with Mr. Strickland and asking him to do some work, did you do any of the work yourself? Run a report, talk to anyone? The envelope, so you are essentially conveying information that you received in some way, shape, or form from Mr. Strickland.
Correct.
And the envelope that you have in front of you, it has a name on it, correct?
It does.
That name is not John Haggard, is it?
It is not.
And is it true anyone could write any name on that?
It is possible.
Well, you said that they're not, and you can correct me if I'm wrong, they're not checking IDs at the post office if you're paying with cash, right?
I don't know their procedure on checking the IDs, but transactional data for, say, a credit card would have given that they were paying in cash. Correct.
So theoretically, if I wanted to go send priority mail, I could write Sally Smith's name and an address in the return mail. And you have, as you sit here today, you're indicating there's nothing to confirm. No one would confirm that with me.
Correct.
And just to be clear, you said it was sent from the East Lansing Post Office?
It was.
Is that the one on Abbott?
I don't know the address.
Okay, you don't know the address, purchased in cash, correct?
Correct.
And you're not saying, you can't testify at all as to who purchased that, correct?
Correct.
And you have no idea who mailed that, correct?
Correct.
Nothing additional. Thank you, sir.
Richard Strickland, you said his name was?
That was my analyst name, correct.
Okay, and that common spelling for Strickland?
I believe so.
Okay, thank you.
If I could, yes, thank you, Judge. Just follow up a little bit on Ms. Chartier's questions. So Richard Strickland still works for the postal inspector?
He does.
Okay. And if I understand correctly, he turned this task over to this analyst because the analysts, that's what they do. They go and they find data for you, I guess, right?
Correct.
Okay, so it's not something that, or this report that he generated was at your request, if he generated a report at all.
Correct.
And you would have asked that because agent from the AG's office had asked you to discover this information, do this, find out about this tracking number and give me this information, right?
Which information are you referring to?
How it was paid for.
Correct.
So all you had is a tracking number. You didn't analyze that yourself. You give it to an analyst because
Correct.
that's what they do, right?
Correct.
Okay. If your analyst had generated a report for you, would you still have that?
Yes.
Okay. And where would you keep that?
That would either be in my emails or in his emails to me. He keeps those records.
Nothing further.
No one else wants to go?
No questions from Kathy Burden.
No questions from Maddox, Your Honor.
No questions?
We know the date it was sent, is that correct?
Yes.
Okay, and we know the time, actually the time on that date?
We could go back and confirm the time of the transaction through the report.
Oh, and like banks, do local post offices have security cameras for transactions?
That depends.
So did you check this location to see if it has a
No.
security camera? So you don't know if the person that dropped off picture was captured? Is that correct?
Correct.
You know how long footage is kept if there is a camera?
That also depends on the nature of the post office.
And so if the camera footage is still there, are you going to investigate that?
If I was asked to, yes.
You've not been asked to?
No.
And Michelle Lundgren's name is not anywhere on that parcel, is it?
No.
Any additional cross-examination of this witness?
George Brown from Mariette Henry. Was Mariette Henry's name on it?
No.
Thank you, brother. No further questions.
All right, an objection.
An objection?
Yes.
Yes.
Because I don't believe that, so I would ask the court to strike the testimony about the information that was obtained because this witness did not do the analysis himself. It was given out to someone who apparently does that for a living. And this is generated in anticipation of this litigation, of the police investigation, just like police reports are not business records. Neither is this report and the data that was obtained by someone else. So it doesn't meet any exception to hearsay if they're offering to prove the truth of the matter asserted.
Is it being offered to prove the truth of the matter asserted?
As to the payment method and the date of delivery, yes, and I still maintain that it is the data that is the focus of the testimony. It is the focus of the information. It's the information that is maintained by the business, which would make it a business record. what the witness has testified to is that he received the request, and as per his policy, he sends that request to his analyst, who provides that information to him. And although he does have access to that information, that is the procedure in place, but this information is retained and obtained from the records of United States Postal Service, United States Postal Inspector Service, which makes it still business data and not hearsay. This information would exist whether the Attorney General's office requested it or not. So it wasn't created for the purpose of litigation. It existed. The department just asked if it was still available.
But my problem is, Judge, is that he didn't get it. He didn't go and look and see if it's there or not. Somebody else did. And whether it's there or not, it had to have been told to him somehow. And if it's a report generated, that's not a business record. Data may be a business record. But the person who knows that is not this witness.
And we're not 100% whether or not there was a report.
But okay, but even
Could have been a call.
I'm saying the report is not a business record. So that's what he's testifying to, is what the report says. He's not testifying that the data is actually there. He doesn't know that.
Mr. Brown?
Marion Henry joins that argument by Mr. Stanley.
We join as well. The witness's testimony has been a little fluid, but essentially he said if there was a report, it was generated at his request based on a request by the Attorney General's office. Again, a report prepared in anticipation of litigation. It is not a business record. That would be a report made at or near the time by or from information transmitted by a person with knowledge if kept in the course of a regularly conducted business activity. That doesn't classify a report if one actually existed that was made at the request of Mr. Vandeputty, that was then made at the request by the Attorney General's office. And again, this witness respectfully is just parroting what he believes he was told, either in person, by phone, or via an email from Mr. Strickland, who is the one who actually did the work. So his testimony should be stricken. I join in. Thank you.
May I respond, Your Honor?
You may, but I am going to say, I tend to agree that if there was a report generated and we're not sure if there was, and if there was a report, we're not sure if it's in this witness's email or not, but why wouldn't that report be akin to a police report?
Because we're not talking about the report that the analyst created. We're talking about the information. The information, which we're talking about, when this document was, when this envelope was delivered and the method of payment, that would be data that was generated and retained at the time of the transaction. And all that the analyst did was go in and pull that information out and perhaps compile it into a report, but he didn't create that data.
But that brings us back to how he got that information, is what the original objection was. How did he get the information? And it went into, well, he may have gotten it through a report, or it could have been an email, a phone call, or he could have went down because it was right down the hallway. We weren't sure how he got that information. And so the question then is, how is this being verified? We couldn't get that. He's not even sure how he got the information. So I think I'll give you time to discuss with your co-counsel.
So, okay, I'm going to interject here, Your Honor. Kayla Crino on behalf of the people. My name was not on the record earlier. The answer to this question lies in the hearsay exception itself, okay, Your Honor. So under MRE 8036, which is records of regularly conducted activity, a memorandum, report, record, or data compilation in any form, and so that's key here, Your Honor, in any form of the acts, transactions, occurrences, events, conditions, opinions, or diagnoses made at or near the time by or from information transmitted by, okay? So what this witness did is he explained the data that was kept in the regular course of business by the post office, right? So we satisfy the first component of that element. It was transmitted to him by someone with knowledge. That's the analyst Richard Strickland we've learned about today. So this 100% fits within the exception for business records, Your Honor. So that's why he's here testifying about it. That's why it's not like a police report, and that's why it's ultimately permitted here.
Thank you for that.
Yep.
Counsel.
So I don't think it is as straightforward as just saying, will they keep the data? Because on the original direct, I believe Mr. Vandeputty said analysts, and he used the plural, make those determinations to get him the information. If there's any determinative factor to this, it doesn't fit under the business record exception. And I think the problem here, quite frankly, is, no offense to Mr. Vandeputty, I think we have the wrong witness here, because he didn't do anything other than potentially receive information in a form that he doesn't remember, and he's here conveying it. And again, he can't even answer some basic questions about that.
Well, was there determinative factors? I'm not sure. Maybe we need to ask this witness if there was, because I recall that he stated that the information, he requested information from the analyst, and that he doesn't recall if they provided a report or not. I don't know what it takes, and I don't think we've gotten enough testimony elicited to tell what it takes for them to pull that data, or if this witness can even testify to that.
And ultimately, Your Honor, I think to answer that question, it doesn't really matter. So if the data is something that the post office keeps in the course of its regularly conducted business, which, yes, I think we all know that the post office keeps track of tracking numbers, and they use those tracking numbers to know what happened with the package. That's really at its simplest form what we're talking about here. A tracking number that belongs to the post office that they use to keep track of what happened with the package. So that information is without question kept in the regular course of business. It was transmitted by someone with knowledge to this witness who's here today. So we're really overcomplicating this. And in a lot of ways, he's nothing more than someone certifying a business record or telling us what it is. It does not matter one bit that in addition to all of that, perhaps a report was created. I don't know. I haven't seen it yet. Our department doesn't have it. But ultimately what we're talking about is data that was properly kept, was properly transmitted to this witness that he's here telling us about today. And that's all perfectly fine.
Well, it matters to us. It matters to us if the data was properly kept. It matters to us if the data was properly analyzed, because who sent that envelope is wildly critical to this case. So maybe it doesn't matter to the government, but I will say, at least on behalf of Mr. Haggard, it matters to us.
Your Honor.
But that's, if I can respond, that's ultimately not what the original objection is, because none of these questions had anything to do with who sent that, right? It was what was the tracking number, what was the payment method, when was it mailed, and what was the date of delivery. So that, with respect, was not the original objection.
Your Honor, George Brown from Mary Ann Henry. I think that the people may have a stronger argument if they have Mr. Strickland sitting there. They don't. They have somebody else who may or may not have received this record. We don't even know. This is clearly hearsay, Your Honor. It's outside the executive.
Well, her response was that he received information from someone who analyzed those records, and that it falls within Rule 806 as an exception.
Just so the record's clear, Your Honor, Kathy Burton joins in all of the objections.
Thank you,
Make that note.
counsel.
Your Honor, Michelle Maddox joins the objection, and I should differentiate that the tracking number is regularly conducted activity, but to go and pull a report about somebody from that tracking number is not.
Pull a report about who paid for it.
Who paid for it, who sent it, when it was sent, where it was sent from. That's something that has to be asked by an analyst, a third party, and then the report is generated. That's not something, a tracking numbers on every single package. That's right.
And you don't believe that the post office keeps a regular record in the course of their business as to who sends packages and the tracking information?
From the testimony, the tracking is kept regularly, but an analyst has to go and generate a report. I would say that is not done regularly.
Oh, generating the report is not done regularly, is what you're saying.
Yes.
Well, I think we're aware of that. They're talking about keeping the actual data is what's being kept in the regular course of business, not generating the report.
That's correct, Your Honor.
But the report's what's hearsay.
We don't know if there's a report.
And no one has removed.
Yeah, we're not admitting a report here. We don't know if it was a report. He was testifying that he may have received it in a report, or he may have received that information directly, word of mouth, from an analyst who he directed to pull that information. Can we ask this witness about, someone had a question about whether or not this information outside of the tracking number included, I thought they've already asked about whether or not information on identity was kept. I believe they did ask that,
They did
but
ask
that
that.
because this was paid with cash, then they wouldn't have that information. So they did ask that information. But they did ask, would that have been kept in the regular course of business?
I thought he said he didn't know for certain what different post office did, and I apologize, it's getting late in the day, so I may be wrong about that. But I thought he said he couldn't necessarily attest that they wouldn't be checking the ID. Did I?
Well, I don't know if checking the ID is the same as keeping a record.
Okay, correct, okay.
Yeah,
correct. Okay, thank you.
checking the ID, they may or may not, but keeping a record is a little different, but we can clarify that.
I did ask that question on direct, whether or not, especially with a envelope that's being paid for in cash, if they would retain information with the person who was actually paying the cash, and I believe the answer was no.
Okay, for the reasons argued up by you, Ms. Pino, I'm gonna overrule the objection, so the statements are gonna come in.
Thank you, Your Honor.
Thank you. And did you have any further questions for this
I
witness?
did not.
Okay, because I don't think anybody else any questions, and but I mean, any other redirect.
No redirect.
Okay, this witness may be excused. There is a sequestration order, so you can't discuss any portions of your testimony with any witnesses or potential witnesses, okay, sir?
Yes, ma'am.
Thank you. It's 3:39. We're not gonna call an additional witness. We are scheduled to be here tomorrow. I'm not sure how many more witnesses the people have.
Got a few.
I think they have 8 more witnesses if that list is holding true.
At least
Might be
7.
9 now. He said,
At least 7.
7 or 8 witnesses. What time are we supposed to start?
30?
Did we have PCC?
No, it's blacked out. Where are this?
Okay, sounds good. So we're going to recess until tomorrow, 8:30. The people will proceed with their next witness. If at all possible, I know there's been a number of exhibits that you needed to try to circulate. We could do that. I don't know if there's a way to do that beforehand, just because we're in a crowded space. Tomorrow is Thursday, which means they'll be crowded outside because the other courts will be doing preliminary examinations as well. And so just to try to streamline that as quickly as possible, I know this is gonna have chaos regardless. Just because of the nature of what we're dealing with and how many different attorneys we have and the spacing accommodations or the limitation that is that we have. So we're gonna try to work that out in advance as much as possible. I know we can't work everything out. And then we'll address any issues as necessary tomorrow at 8:30. Any additional matters before we adjourn today?
Your Honor, I had a question. George Brown from Marion.
Yes.
In the event that we do not get through all the other witnesses tomorrow, are we going to be moving through on Friday? Or is there an alternate date?
It will not be Friday because I have a whole nother preliminary examination docket on Friday. You'll just have to get another date and we'll have to figure out what that looks like. With the remain, it's 6 of us now, with 7, with those calendars and the holidays.
One other point, and I don't anticipate finishing tomorrow, but maybe we will if we're.
I don't anticipate it either.
So when the exam ultimately does finish, would the court consider allowing us to brief the issues? Because I think they're so dense that to verbally, at least from my perspective and Mr. Krause's, to actually have to speak them, I think
No,
writing.
it was gonna be a request.
Okay, great. Thank you, Your Honor. Okay.
No, I think of maybe once or twice I've already had an exam that went several months continuation over, and that's the only way that's the most concise way to do it, especially when you have all of these attorneys. The best way to do it. So, and I don't know that we'll get a 3rd day scheduled this month. And so, or January, because I think we struggled with timing for the next half of the co-defendants to get them into January. So there'll be some time in between there. So we'll figure it out best way if you have to block something off to try to get this one. I would prefer to finish this before I start the next, to be honest. So we'll try to work the schedule out to do that.
Thank you, Your Honor.
I anticipated that most psychologists would have transcript requests And those are like certain, they're not iffy as they are sometimes. And since it appears we won't finish tomorrow, it might be into January before we finish. If you could treat this, at least from Ms. Lundgren, if they could begin the transcripts now, that probably would be, that would make it quicker for us to analyze, file the motions for the court to hear and get this case either dismissed or moved on.
We would join that request.
I think we have to submit official request in writing to
It's
do
gotta
that.
be an official request, and I can tell you now, the transcript request has been running behind because everybody's running exams now. So.
All the more reason to make it as
Let's see
early
if
as
we can,
possible.
let's see if we can get Mary in. She's already open. Oh, well, no, there we are. We've been outsourcing, we're doing the best we can to try to get them. And so we'll do the best we can for this, but we can't cut the line just because you all want this at a certain time frame. But we'll do our best.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Your Honor.
Thank you.
John,